Good evening. Shana Tova. That was terrible. Shana Tova. My rabbi would do the same thing, I think. So first, let me thank Scott for that lovely over-the-top introduction. Meeting Scott is one of the great gifts of my time at Princeton University. He is a great lawyer, a warm and generous person with a wonderful sense of humor, somebody who needs a slightly higher microphone than I do. He's a terrific friend who also has an extraordinary appreciation for the obligation of lawyers to make the world a better place, to perform tikkun olam. You can see that in his commitment and the commitment of his law firm, McCarter & English, to a host of civic projects, including the future of the city of Newark. I want to thank Rabbi Lubin. Did he move? He was. Oh, there he is. I want to thank Rabbi Lubin not just for the invitation to speak tonight, but for having the foresight to start this symposium and for bringing this group together year after year with such ability and enthusiasm. It is because of Rabbi Lubin's reputation and the continued success of this gathering that I accepted his gracious invitation to speak tonight. And now that I saw the video with all the people in our legal community who have preceded me, I am even more honored to be in their company. But Rabbi Lubin's invitation and his reputation is not the only reason that I wanted to be here tonight. As Scott pointed out, on March 10th, the President of the United States, the current President of the United States, not the one who appointed me, requested my resignation as United States Attorney. As my British friends would describe it, I was thanked off. So as the clock rolled from the 10th to the 11th of March, as we crossed the midnight hour, I became unemployed. Now, Scott explained that I am a distinguished visiting fellow at the Seton Hall School of Law. Translated, that means I'm really just the chief Jewish kibbutzer at a Catholic law school, which has become really important because now that Jeff Sessions is the Attorney General, it's really more about Old Testament vengeance than it is New Testament turning the other cheek. But it's not a full-time gig. And I've begun to sort out what I want to do next. Scott alluded to that. And I've had many conversations, some more serious than others, with many firms and other institutions, including some who are represented in this room. And yes, I have prospects. But I have yet to settle exactly on what the right fit would be. So in the spirit of Yom Kippur, which of course will be upon us in only 72 hours, I've decided that it would be okay to use tonight like an old-fashioned traditional Yom Kippur pledge drive. Almost a bidding war, if you will. I have a number in my head. I won't tell you what it is, but if one firm, any law firm, hits that number, I will pledge 10% of my first year's draw to his Chabad. Take your time, be generous, I'll see you on the way out. So when I accepted this gig back in February, I really had no idea what the issues du jour would be. I just assumed that there would be something that would pique my interest in yours. And sure enough, there are a few topics that could warrant some discussion, like yesterday's retooling of the travel ban, Bob Mueller's investigation, no-knock search warrants, threats to indict, conflicts of interest, and obstruction of justice, the use of private emails to conduct government business. It's back again. The president's assault on the court system, his relentless attacks on the press, his failure to comprehend that Colin Kaepernick and every other athlete in every other sport has the right to kneel in protest, stand up, sit down, join arms, go out in their pajamas, or express him or herself in any way that might or might not turn out to be disrespectful to the flag or to the views of others who express their love of country in a different way. And it doesn't mean that those athletes love their country any more or less than the president, or that they are any more or less patriotic. Then, of course, there's a topic that Rabbi Lubin actually selected and around which he's constructed the panel. Law, medicine, and the pursuit of justice, individual rights versus societal obligations. And then, on the inside of the flyer, law, medicine, and the right to decide. Now, without criticizing the rabbi, because what percentage can there be for a nice Jewish boy to criticize a rabbi during the holiest week of the year, I will say that I was surprised by the topic when I saw it for the first time at breakfast 2 weeks ago. Already printed. The paper equivalent, if that's possible, of the tablets of stone from Mount Sinai, with three very accomplished panelists who were no doubt selected entirely because they are smart and well-spoken and because they are obviously very well-versed in the very interesting and important topic that's on the brochure. But if I wanted to talk about medicine, I would have gone to medical school. Since they are undoubtedly so very well prepared and no doubt eager to share their thoughts, I will largely leave the broader discussion to them. And if I were an Orthodox Jew, I would feel some very serious motivation, even an obligation to follow the rabbi's direction to talk about that topic. But as a Reform Jew, I know that the rabbi's choice is merely a suggestion that I am free to ignore or modify in any way that seems appropriate to my own life. So here's what I'm going to do. I'm going to leave out the medicine part, and I'm going to weave around the part about individual rights versus societal obligations. Instead, I'm just going to focus on the tiny little part of the title that says, The Pursuit of Justice. And I'm going to share some thoughts about how that plays out in the federal criminal arena, using as examples or touchstones a few recent events with which I expect you are all familiar. And of course, since this is a Jewish law symposium and we are in the middle of the days of awe, I will try to tie it together with some allusions and references to the liturgy of Rosh Hashanah and Yom Kippur. So let me take you back a year, last year, to Kol Nidre, and an experience that will be familiar to many, maybe all of you, who are members of a synagogue. In mine, Temple Ner Tamid in Bloomfield, as in the synagogue where I grew up, Temple Shalom in River Edge, the rabbi and the temple's leadership used the opportunity of the high holidays to recognize those who have given to the temple, either financially or through service. So last year, I was asked if I would participate in the Kol Nidre worship by serving as a Shaliach Tzibur, by coming to the Bima and reading from the Machzor and briefly leading the congregation in prayer. And the particular portion that I was assigned was the Vidui, the confession of sin, the short one and the long one, the Ashamnu and the Alchet. So after the cantor led all of us in chanting the Ashamnu, I led the congregation in reading aloud what is undoubtedly a somewhat modernized interpretation, a loose translation of the original. And then I did the same with the Alchet. Both prayers, of course, containing a recitation of the sins we have all committed either individually or as a community. Of course, as is our tradition, it isn't expected that everyone in the congregation have committed every transgression on the list, but it's a long list, a comprehensive list, as you all know, and includes some very specific admissions to the kind of conduct, stealing, killing, that I was prosecuting at the time. So I led that reading and the rest of my assignment with gusto, perhaps adding pride to the list of my own sins. The next morning, Bob Rich, who is here, where's Bob? Who at the time was the chairman of the committee of our temple that calls the Religious Activities Committee or the Worship Committee, whatever, every temple has one. He came up to me and with great excitement and admiration assured me that I was undoubtedly one of the finest prosecutors who had ever lived. Now, the Bridgegate trial had just started, so naturally I assumed that he was complimenting me on the skill with which my office was navigating some pretty tricky waters. Maybe more pride and another transgression on my part, but still, as certain as I was, I feigned modesty and humility and asked him what he meant. And of course, it had nothing to do with Bridgegate or my actual duties as U.S. attorney. No, here's what he said. Some prosecutors get one person to confess, some 2 or 3. You, he said, got an entire sanctuary of 700 Jews to confess all at once to at least 2 or 3 dozen crimes. Very impressive. And I have to admit that while I was standing up there on the bima, I too had been struck by the irony of my role in the service, because of course I too had confessed to all of those same crimes. So when I mentioned it later that day to the rabbi, my good friend Steve Kushner, a more than small smile played upon his face, owning his role in the entire episode. Now, if I were still the United States attorney, I might stop there and dwell solely on the importance of confession, the way it can cleanse the soul, its critical role both in our faith and in the criminal justice system. In my professional world, in the world of criminal justice, the confession is often the first major step in the road back. It is, of course, often the most powerful and important piece of evidence in a case. And for those who want to cooperate and testify against others and to help themselves by assisting in the investigation and prosecution of others, credit is not available unless and until the defendant takes the first step of fully and completely describing his or her own role. And a confession, if publicly undertaken in the form of a guilty plea, often brings some closure to victims and the public who need to hear someone own the responsibility for the pain that he caused. In our religious tradition, too, there is no true atonement, no real teshuvah, without an acknowledgement of what we have in fact done, of the wrongs we have committed, of the responsibility for our actions, for our choices, for our thoughts, for our behavior. We must declare our complicity, first to ourselves, then to our loved ones and friends, to our colleagues and our community, and ultimately to Adonai. And that, of course, is what makes the Vidui and its public and communal character so central to our worship on Yom Kippur. But as you all know, in Judaism, confession is not actually the point in the end. It's important, it's critical, it's necessary, but all of that is true because confession is a prerequisite to something more significant. It is one large step, but only a step on the road to teshuvah, a road that returns us to what we hope is our true self, and a road that we pray leads to forgiveness. And again, forgiveness first from those we have wronged and to whom we owe not just a confession, but an apology, and of course, forgiveness to and from ourselves, and ultimately, again, forgiveness from God. But when we ask for forgiveness, what are we really asking for? And maybe more important, what do we expect to get? Is the slate really wiped clean, as if we had never sinned at all? Can God actually forget what we've done? Can we? Can our loved ones or even strangers? Haven't we done things? Haven't we taken action, engaged in behavior that sometimes was so terrible, or even if it wasn't, was bad enough and that could cause enough damage that it's impossible to pretend that nothing ever happened? And if God can't forget, as we ourselves often cannot, when we ask for forgiveness, what are we actually asking of ourselves? What do we actually ask of God? Is it to let us off the hook with no punishment, no sanction, no consequence? Are we really asking for absolution, or are we asking for something else? Something for which we give words not just like forgiveness, but words like mercy or compassion or lenience. And what does that look like? Well, I'm hardly a rabbinical scholar, so to answer those questions with any authority, I'll ask later if I can talk to the people at the Tuesday Talmud table, or to others with serious and comprehensive knowledge of Torah, Midrash, and the Talmud. And for that, you would certainly need a different speaker. That's not so much in my lane. I am a parent, as are many of you, so perhaps I or you could speak with some experience on how we apply those concepts in our own homes. Who among us hasn't had to deal with irresponsible or mean or thoughtless behavior of a child from whom we often demand a confession and tell them they have to apologize, as if telling someone that they have to apologize, and when they do, that it's actually an effective and meaningful apology. But even when the apology and the confession come, we're confronted constantly with the dynamic of consequences and forgiveness. So I could talk about that, but so could you. So instead, I want to relate that briefly to the criminal law, where the notions of mercy, compassion, lenience, mitigation, forgiveness, and absolution play a pretty huge role. And maybe that will give us some insight as we think about what we want and expect during this Holy Week. So what happens first in the criminal process? Somebody does something wrong that comes to the attention of others, to the attention of cops, agents, investigators, prosecutors, who have to make a call right out of the gate, whether to bring down the hammer of the federal or the state criminal legal machinery on the head of that person. Should he be arrested? Should she be charged at all? And if so, with what? How severe or numerous should the accusations be? This is the time-honored, but sometimes derided or maligned and certainly misunderstood moment of prosecutorial discretion. To be fair, sometimes those decisions are not always about discretion. Sometimes they're simply a function of proof. There isn't always sufficient evidence to indict and convict and to prove somebody guilty beyond a reasonable doubt, even when the prosecutor may know or believe that the circumstances and the person and the conduct deserve it. Sometimes, on the other hand, it's just a question of allocating limited resources. Sometimes there just isn't enough time and aren't enough people in law enforcement to go after every single crime and every single thing that somebody does wrong. We just don't have the bandwidth. But usually, how someone is treated turns more on the application of both common sense and some measure or lack of compassion. There are lots of individual examples, but drug cases as a category illustrate that kind of approach and what I'm talking about. The weight of the drugs possessed by a defendant is often the touchstone of potential punishment and is always the potential trigger of mandatory minimum sentences. But there are cases in which those mandatory minimums require prison terms that, in my view, are more significant than necessary or appropriate. So the approach of my office, which the Attorney General of the United States, Eric Holder, made policy department-wide, meant that even if a defendant possessed a quantity for which the law could require 5 or 10 years in prison, even if he didn't have a gun, and if he didn't have a history of violence, and he wasn't really tied to a gang, and wasn't high up in the food chain, we could charge an indeterminate quantity, not naming the number that would get that person over that mandatory minimum. I thought that was fair. I thought it was right. I thought it was cost-effective. And even though it turned on some measure of mercy or compassion or lenience, it was smart, effective law enforcement, no matter what Jeff Sessions now thinks. Sometimes that sort of compassion, although it looks like common sense, becomes appropriate after charges are brought. First, of course, there's plea bargaining. And I can't count the number of conversations that I had with members of my staff over 7.5 years in which we had a long and meaningful, passionate discussion about what plea offer to make for a defendant. And those discussions, by the way, we had thousands of cases in the office. So those are only the ones in which I participated. I have no doubt that there were hundreds and hundreds more. Those discussions were replicated all over the office. Why? Because a rigid application of the federal sentencing guidelines, more than occasionally, would have resulted in a sentence that seemed to us to be too harsh. Yes, sometimes too light, but not nearly as often. And so I encouraged my colleagues to reach plea bargains that took into account how we felt about the severity of punishment. Did confession play a role? Acceptance of responsibility? You bet. But so did other factors that militated in favor of lenience and compassion or against them. We also started a drug court. Certain defendants who committed nonviolent offenses while suffering from a substance abuse problem or addiction were offered agreements that allowed them to plead guilty, postpone their sentence, and go to rehab. And if they completed the treatment regimen successfully, they would receive real consideration at sentencing, with probation instead of jail as a real possibility. Mercy, compassion, lenience, and maybe a dash or two of forgiveness? Absolutely. I don't want to dwell on the entire criminal justice process, and I'm certainly not going to talk much about sentencing, because that's the stage at which the application of all of these principles, all of those values, so obviously applies. In fact, it's the very rare sentencing in which a defendant does not ask the court for mercy and forgiveness, with at least an effort at an apology and some meaningful effort to demonstrate remorse. But it's also the rare sentencing in which, much like we expect on Yom Kippur, there isn't a real attempt by the prosecution and the judge to determine the sincerity with which the defendant is making that plea. Just like on Yom Kippur, forgiveness must be earned, although we have considerably less power and ability to look truly into the defendant's soul than does God. It is also, honestly, why defendants like Bridget Kelly and Bill Baroni, who we said perjured themselves on the stand, get sentenced more harshly. Partly, of course, it's what we perceive to be a disrespect and undermining of the system, which requires people to tell the truth. But it's also because, by testifying the way they did, they totally rejected their own complicity and demonstrated the complete opposite of remorse. Denial and subterfuge do not lead to forgiveness in court or in shul. And just as an aside, only because he was sentenced yesterday, I recommend that you read the letters to the court that were written by Anthony Weiner and his soon-to-be ex-wife, Huma Abedin. You can find them online. It will give you real insight into why he got the 21-month maximum sentence for which his plea agreement provided. His letter, while in my view professing to apologize and reflect humility, really reads differently. And his wife's letter seeks lenience only because of the effect that his incarceration would have on their very young son. There is not 1 ounce of forgiveness in the 3 paragraphs she wrote to that judge. So last, I want to turn to the part of the process that really is directly about forgiveness. And that's on everybody's mind a little bit today because it's the constitutional power of the president to grant clemency, either through pardon or by commuting or shortening a sentence. So the way the Justice Department's process ordinarily works, before the president gets the pardon application, it goes to the Department of Justice. The Department of Justice doesn't accept applications from people who have been convicted for fewer than 5 years, have not demonstrated good conduct since then, and haven't shown real remorse. The pardon power, which is enshrined in the Constitution, is there because, as Alexander Hamilton put it, otherwise justice would wear a countenance that is too sanguinary and cruel. And so there have been a long history of pardons in the last 200 plus years. And there have been a slew of bad pardons, pardons that if you looked at them, you would say, that's not a good one. President Clinton's brother, Gerald Ford's pardon of Richard Nixon, still very controversial. Thomas Jefferson pardoning people who were his political allies for violating the Alien and Sedition Act. Richard Nixon pardoning Jimmy Hoffa for jury tampering and then getting endorsed by Jimmy Hoffa. There are a slew of pardons, if you go and look, that were controversial at their time and many of which would outrage you today. The pardon of Joe Arpaio stands right at the top of that list for me. Because while the president does have the complete pardon power, and in effect, that's the ultimate exercise of prosecutorial discretion, my view is that that power should only be invoked when there is real remorse, and at least, if not real remorse, at least an acceptance that you have in fact done something that might in fact be wrong. Joe Arpaio is defiant, and he's defiant about something that we all hold incredibly dear, which is the right to have cops treat you in a way that is constitutional. And so 17 months of defying a federal court order, to me, does not justify a pardon. Maybe after the process played out, if he had been sentenced and he was in fact an 85-year-old man who had done service to the public in other ways, perhaps clemency might have been the answer and maybe no jail time, but not that. That to me was not exactly the way it should have worked. Other instances of clemency recently have also gotten on our radar. One was the decision by President Obama. And by the way, there's no prouder moment in my life, short of watching my own kids play baseball, there's no prouder moment in my life than hearing somebody say that I was nominated to be the United States Attorney by Barack Obama. It still rings great. But President Obama decided that people who'd been sentenced for various drug offenses in the 1980s and 1990s and early 2000s may have gotten sentences that were longer than the ones we would impose today. So he put in place a clemency project to get people to apply for reduced jail sentences. And he ended up granting 1,715 clemencies, reducing the sentences of 1,715 people, dwarfing by far the number of sentences that were reduced by any other president. However, President Obama only granted 219 pardons, which makes him the third most parsimonious pardon granter. Yes, Scott, that's another word I can spell. Third most parsimonious pardon granter since 1900. The only two who granted fewer pardons than Barack Obama were Bush 41 and Bush 43. But those the clemency applications that the president entertained, the factors were the defendant likely would have received a much better deal or a much lower sentence if prosecuted when we were the U.S. attorneys. We wanted real evidence of teshuvah. We wanted remorse. We wanted productive time in prison. And we wanted a commitment to a crime-free life on release. Now, it's true that I didn't meet any of those people. None of the people who applied for clemency. And I personally couldn't know what was in their hearts. But I have hope for all the ones whose applications I endorsed, that they were sincere and that they will succeed. Is that lenience? It is. Is it mercy? It is. And maybe a measure of forgiveness, too. Last clemency I want to talk about is Chelsea Manning. And I don't want to talk about the bona fides of the Chelsea Manning clemency. Chelsea Manning got 30-plus years in jail for giving away hundreds and hundreds of thousands of documents to WikiLeaks, all of which revealed a lot of classified information that, in the judgment of a lot of people, should not have been released. Went to trial, admitted her guilt, got convicted, got sentenced, and by all accounts, endured a very terrible time in prison. And President Obama decided, as an act of executive clemency, to reduce her sentence to time served, effectively 7 years. We can have an honest debate about whether that was a good thing or a bad thing, whether it was a good or bad use of clemency. But here's the thing that struck me about that controversy in the last 2 weeks. Harvard University invited Chelsea Manning to be a fellow in one of its programs up there. The naming of Chelsea Manning as a fellow in that program joined other people who had been invited, including Sean Spicer, and Corey Lewandowski. The head of the CIA and the deputy director of the CIA decided that they would not continue to hold or accept the positions at Harvard that they had, because they found that giving that honor to Chelsea Manning was not, in fact, appropriate. You can quarrel with that issue if you want, but here's what the head of the CIA said. He said, you can't be a fellow at Harvard and be a convicted felon. That strikes me as wrong. That strikes me as wrong because at some point, when the process is over, people have to have a way to get redemption. At some point, unless something is so terrible, there has to be some way in which we can find it in our hearts to forgive. And if you'll indulge me one more thing, I'll tell you a brief story about one young man named Daquan Rosario, who I know very well now, who was arrested for the first time in 1994. He was 16. Looking back, it may not have been that much of a surprise. When he was growing up, he would leave the house where he would go to school. He would step over the bodies of family members who were passed out on the floor from taking drugs. When he came home from school, he had to step over those same bodies. In 1995, shortly after he turned 17, Daquan was arrested again. This time he was sentenced to his first term of incarceration, and the spiral continued. 10 years later, at 27, the office I just left prosecuted him for drug distribution. I was not the United States attorney at the time, and the office asked for and received a 10-year sentence. Doesn't matter how the federal prison system works, you don't need to know that, but they have levels of 1 to 6. The lowest levels go to federal prison camps. The highest risk go to Supermax in Colorado, and everybody else you get assigned based on your criminal history, the nature of your offense. And often you get sent away to prison. So Daquan got sent to Oklahoma. So for the first 4 years he was in prison, he received no visits from family members. He was finally released in 2012 or early 2013. Before he left prison, he was given 2 things. He got some street clothes to replace his prison jumpsuit, but they weren't his clothes, they weren't nice clothes, and they didn't fit. The second thing he was given, as he put it, was enough money to buy a bus ticket and a couple of slices of pizza and a Coke if the bus stopped on its way back to New Jersey. So when he got to the federal halfway house in early 2013, here's his inventory. He was 37 years old, holding nothing but a high school diploma. He had no job skills, no job history, except for positions he held in prison, no money, clothes that weren't his and weren't very nice. So what did he do? He managed to get a job flipping burgers at Burger King. That job gave him little self-respect, and he quickly realized that it would have been easier and more lucrative to go back to the street and sell drugs. And guess what? Like a lot of men in his position, he had old friends from the neighborhood approaching him every day, trying to get him to do exactly that. And we know how many people yield to that temptation. But he wanted to change. He wanted a better life. He just wasn't sure how to do it. He wanted teshuvah, but there was nobody yet there to lend him the hand he needed. One day, while he was living in the halfway house, he was visited by a federal probation officer named Kevin, who works in Newark. One of his jobs, Kevin's job, is to supervise newly released prisoners. But that day, in the winter of 2013, Kevin was there wearing a slightly different hat. He was there to ask Daquan to participate in what was then our new federal reentry court. They started to talk, but as soon as Kevin said to Daquan, "You're going to have to come to the federal courthouse every 2 weeks to meet with other people like him and a federal judge," Daquan said, "No way, I am not going back to that building." And who could blame him? The last time he was there, a different federal judge had sent him to prison for a decade. But Kevin is persistent. He's gentle, but he's persistent. He said to Daquan, "Come once, try it. If you don't like it, I won't bother you again." So Daquan came, and he realized within 20 or 30 minutes that he had found his shul. He found the place where he could be safe, a place where he could get help, a place where he wouldn't be tempted or threatened to go backwards instead of forwards, a place where everyone there was just like him. So what happened? Well, the people who work in that reentry court brainstorm every week about how to help the men. There's only been one woman in that program. They helped Daquan get a job working for a medical transport company. That's a fancy way, basically, of describing him as an ambulance driver. Private ambulances that drive vans and transport patients. And when Daquan said he wanted to become an EMT, the team helped him get into the training program. And when he finished that program, sometime in 2014, Daquan got a job that he still holds as a full-time EMT employed by Essex County. He has an apartment, a car, and the last time I saw him, he told me how bummed out he is that he is still, because he's still under probation supervision, he can't yet register to vote. Now, all of that is pretty amazing, and I'm pretty proud of him and the people in the federal family who took so much time to try to help him and the other participants. But here's what's more amazing. Some of you may remember that 2 years ago, November, President Obama came to Newark to talk about and highlight drug treatment programs and prisoner reentry programs. He first went to Integrity House, which is a wonderful institution in Newark, and got to see up close and firsthand the challenges and successes of that remarkable place. And then he went down the street to Rutgers Law School to give a speech about prisoner reentry and to announce some initiatives like banning the box for those applying for federal employment. But before that speech, he sat down with 10 of us for an hour-long conversation. Mayor Baraka was there, Senator Booker was there, Judge Madeline Arleo was there, Kevin Ugly, the probation officer, was there, I was there. And Daquan was there, a former federal prisoner who had gone to jail for 10 years for drug dealing, sitting 2 feet to the left of the President of the United States, no farther than these two guys are to my right. And I, like everybody else in that room, sat mesmerized as Daquan, unflinching and unintimidated, told the President the story I just told you, but he told it better because it's his story, not mine. And I can't overstate for you the visible impact that story had on the President of the United States and everybody else in that room. The rest of the hour was fascinating, don't get me wrong. And we got to discuss what's great about federal reentry programs and their obstacles. We talked about staffing and resources and scale. But when we walked out of that room, the thing that stuck, the thing that all of those people still remember, the thing that moved the President of the United States was Daquan's story, his eloquence, and his poise. You don't have to take my word for it. Just go watch the speech on YouTube that the President gave 15 minutes later. Only a few minutes into that speech, the President stopped, announced he was going off script, and described for everyone watching and listening what he had just seen and what he had just heard. And as the President of the United States himself put it, Daquan Rosario was now helping to save lives instead of ruining them. The President's not the only one who was touched and inspired by that work. And I'm not just talking about the ex-offenders who managed to reach deeply into themselves and with help and guidance to become mature, responsible, self-respecting citizens, spouses, and parents. In fact, my experience that kind of program was not only good for the lives of the program participants, it had a profound and lasting impact on the lives of everyone involved. I've watched it soften the hardest and most cynical federal prosecutors into champions for its cause. I saw federal judges call their own personal and professional contacts to ask for housing and jobs for people in the court. And I saw it inspire my own son, Ian, who is now 15, when he celebrated his bar mitzvah 2 years ago. The Sabbath of my son's bar mitzvah, and this is where I'll end, the Sabbath he became a bar mitzvah, the Torah portion was Vayera. And it includes, as most of you know, the story of Sodom and Gomorrah. It's a complicated story, full of moral ambiguity, and as so many of those stories are, in which God tells Abraham of his intention to destroy those two cities because of the wickedness of their inhabitants. Abraham, of course, tries to talk God off the ledge and proceeds to bargain on their behalf. And as you know, first he asks God if he'll spare the cities if he can find 50 righteous men, and God agrees, and he can't. And then 40, and he can't. And 30, all the way down to 10. And finally, when he can't find 10 righteous men, he gives up and God destroys the cities. So when Ian did his Devar Torah, he asked the question if God knew, and he must have, how it would all turn out. Why did he bother telling Abraham in the first place? If Abraham was destined to fail, God must have known that. Why did God bother to let him negotiate at all? And Ian's take was that Abraham needed to learn he had the confidence to be the leader of the Jewish people. And he tried to explain what the attributes were that Abraham had demonstrated in that episode. I won't go into all of it because it would be like too much father pride. But the one thing I will say is that he said Abraham stood up for innocent people that he didn't know, and that it was better to let the wicked go free than to let innocent people perish. But the other thing he said was that because those people deserved a second chance, another lesson we learned from this week's Torah portion is that even if people do something bad, then maybe they deserve a second chance, and maybe we should think about how they get punished. So his Tikkun Olam project for his bar mitzvah was to help those prisoners in our reentry court learn when they got out of prison how to use an iPhone and how to use an iPad and how to use Facebook and how to use Instagram, because they've been in prison and they've seen it on TV, but they had never held them in their hands. And so he concluded that I believe that these returning prisoners have learned their lesson, and I think they should get a second chance. I'm glad they get that second chance, and I'm glad they can help them have it. I think Abraham would have wanted the same thing. This week, we think about second chances. We think about them mostly for ourselves. That's what we will ask God for when we go to shul on Friday and Saturday. We'll ask it for our friends and our family, but we will mostly be inwardly directed. That's not, of course, entirely true. There's a lot of the liturgy that deals with forgiveness for the world, and we will think also a lot about the world. But what I would ask all of you to do as you're sitting in shul, thinking about all of the things for which we should be praying, to think a bit about what the role is and should be for teshuvah, for redemption, for forgiveness in the criminal justice system. We've reached a point in our society where those issues unless we figure out how to solve them, will plague us for decades and maybe even generations. And in the spirit of the holiday, let us pray for that. Avinu Malkeinu, Almighty and merciful God, answer us with grace, for our deeds are wanting. Save us through acts of justice and love. L'shana Tova.